Absolutely. The chairs are all funky.
This is very small. No, big.
One, two, three, 4, 5. Microphones are hot, by the way, so mind your P's and Q's.
Thanks for the warning.
Yeah, I got a ticket.
As soon as I type in everybody's email address, I'm going to forward you the email that has the attachments.
You want to creak it along? Are you not going to especially something like this that just only is like this. Well, you can show about how the federal government didn't need to army because it had state, I don't know, it had state routine enforcement laws. You could pass a law to still enforce them. So our state officials, like just say police, required to enforce federal laws. If they are, they're not required to enforce federal laws.
And remember that when that's what the federalists are suggesting, it's not even clear that those who really believe that that's what happened. Because Because remember the specific circumstances.
No, they're probably all elite in some reason.
Operating.
July 15th.
I'm just gonna give it. They have reason to believe that perhaps things won't go quite as they were suggested or something.
That's a Kamala Harris.
State employees can't enforce federal law.
That's
The
the
section
big,
where it says like
that's the
you
big issue.
can't be compel state employees to enforce the law.
Now, states have decided they want it. So, you know, you get, this is like Arizona, it's reported for the PC. We're gonna have our state law better. I think I just forwarded the reminder to everybody, so hopefully you guys got it, that's why we'll get it soon. It's pretty big, so I think. I love it. It's just because
And I think I have a magnet on it. And just kind of to communities that we're not use the part Next one that we read into. The one that we read into awkwardly. Yeah. That was weird.
Vegan options are available for entrepreneurs.
That's good to know.
He works at the end just on the side. Oh, just I had a really quiz today, but I think I forgot what some looked like, but everything else I remember. S turns into Z, and H is B and T. So like when they have those posters, I don't know what that says. I might remember what it means.
1, 2.
And I'm gonna attend the.
I'm already here.
Here, back there.
Well, I'd rather sit on. Yeah. Okay. I may need to. Okay. How are you?
Yeah, I think I'm fine. Yeah.
I know when Dr. Seuss. No.
Yes, I am. Always. How about you?
Yeah.
Interesting names. Good group.
What's that?
Do you remember what year this started?
Yeah, we have some kind of commemoration when it's its 20th anniversary.
It wasn't here when I was here.
When were you here?
60, 77.
I wasn't here then.
I know it wasn't. Even this building wasn't here then.
There was a law school.
But it started out 67, 68, we were in the basement of Land's dorm.
That's pathetic.
And then next year, they took the whole library and renovated it. So it's right there behind Ringo. Right there. Until this was built.
So the law school only changed it.
The law, this building?
No, the law school is.
The law school is about 17.
University.
No, the law school does. The college is like 1693. It smells like much.
But anyway, they got
I think my graduating class was
big
39.
window, it's kind of stainless with it one black stone.
The scariest one was my senior third year. I had labor law with the dean. And there were 3 of us to class.
I do the reading and show up.
If somebody was sick, you were going to watch.
You were on, I think that.
Yeah.
Are you working in any interesting cases?
Oh, this, I just keep fighting Jeremy over and over again. It's like Groundhog Day.
That's all.
Another case after case. But it's hard to be too optimistic.
Sure.
Which state are you working in?
North Carolina. You already won it. It's already back to the court. It was PR in June. Corporate. See whether John Roberts can come on. Let's see. I keep telling them what to do. No, that's
New
money.
policy with regard to local
We'll
government.
figure out that as many Democratic candidates.
You know, we have some report.
So we had an
Not
hour.
that you didn't do any pro bono work, but that you did do pro bono. Except for in Virginia.
Hey, Elton was on the board election. I think Northam gave him.
Yeah, that's not even in a red bar.
Eventually, does it get thrown to the court?
Yeah, I would draw the line.
I pay my dues, stay active. That's about it. Good night, see you. How are you?
You good? How are you?
I don't think it has an impact.
So what have you done for me lately?
The impact that I intended.
I do.
Are you pointing at me? Yeah, they talk about, should we have mandatory? Seems to be a little contradictory, yeah.
Yeah.
Always on.
Yeah, that counts and everything.
She teaches too.
Right.
So it's not like they teach.
So I think I'll let
I'll be playing the box until
your way.
but I don't know.
Texas like this place, you got it.
It's called Tic Tac Toe. They strategy. Where'd you No.
It's amazing. It's amazing.
Okay, clearly you don't.
So much pressure.
You don't have to go off so many will have specific computer, it's just
Individual institute for rights.
Used
To which way they turn.
What the National Guard was. It's like sulfide red. Change.
That's exactly why you give me that ear. But it's using
Not too much.
So I didn't know how to pronounce it. Oh, okay. My co-counsel says that. But I think it's.
When you, their name.
Yeah, I would have guessed.
Very nice. Okay, let's make sure. Okay.
Looks like calling Jeff meeting too. But I usually sit around.
All right, Jefferson.
Well, I'm just telling you what the opposing process. Okay, so let's say. Really? It's the closest I can come. Yeah, but I've only seen the transcript. I've never heard a tape.
I prefer signs to fingers.
Yeah, it's easier to say.
Yeah, because fingers is like baseball. You know.
Yeah, where will you be? Can you sit like right there so that we can see it? So he's gonna go and I'm gonna sit in here. 171174, Revis versus Bartlett, and I'll say, Mr. J, do you want to then everybody knows what's going to be happening, and then so he has 25, 30.
Make what shorter?
Like instead of 30, should we go 25?
It's totally up to you.
Oh my God. We'll make it easier. Let's do 30 and put 5. Okay. Yeah, and then kind of pointing for these people too.
So from here, if yeah, like pick it up and do your best to make sure I see it. I guess.
Or do you have to sit in the choir? Like, is that easier?
I probably would if you sat closest to the whiteboard, maybe. Yeah, would that be okay? Ooh, this is snazzy. So is that okay if I start here?
Oh, sure. Yeah, for sure. Just as long as they're like really big.
It's a wave it.
Yeah.
Yes.
I mean, I don't have to. I don't have to worry. I mean, I only get my 30 minutes either way.
The worst thing that will happen is they'll tell you you're out of time.
Yeah, at which point I'll say, but I have so much more.
There's more. Special focus.
How much would you get? How much would you get? 1983? 2018?
I don't know. So, be mad about that. Yeah, that's the thing.
She can just say thank you.
Thank you, counsel. Your time has expired.
Thanks. I'll give you a warm welcome. Oh, thank you.
Oh, thank you. Key equipment. OSG Moore says that Six Pillars or somebody once said, may I complete the sentence?
Hi, we're going to get started now.
Probably she was wearing pants. Not me.
Just move.
All right. Welcome. My name's Neil Devins. I'm a law professor here at William & Mary, and I'm director of the Bill of Rights Institute. And on behalf of the Law School and the Bill of Rights Institute, welcome to our 31st Supreme Court preview. Like every preview, we begin with the Moot Court on one of the term's most talked about cases. And this year we begin with Neves v. Bartlett. The issue presented is whether a First Amendment retaliatory arrest claim can be pursued when there's probable cause to make the arrest in the first place. In the spring of 2014, Alaska troopers Louise Neves and Bryce Waite were patrolling a large outdoor party connected with the Arctic Man ski and snowmobile race in Alaska. Trooper Waite began speaking to a minor at the event, thinking the minor might be intoxicated, drinking alcohol, and Russell Bartlett, who was at the event, intervened Trooper Neves then intervened in the conversation between Bartlett and Wade and wound up arresting Bartlett. And the district court in the case found there was probable cause for this arrest, that the officers had probable cause to arrest Bartlett for harassment, disorderly conduct, or assault. Bartlett contended that the arrest was retaliatory, made in connection with something that happened earlier in the day when Trooper Neves asked him to move a keg of beer, and he did not make contact with the trooper, did not communicate with the trooper. Bartlett claims that when he was arrested, the officer said to him, quote, "Bet you wish you would have talked to me now." Bartlett then filed suit. Among other things, he filed suit for retaliatory arrest. The district court dismissed the case because of the probable cause finding, but the case went to the Ninth Circuit, where the district court determination was reversed. The Ninth Circuit said that Ninth Circuit precedent supported such retaliatory arrest claims and that the Supreme Court had not yet addressed the issue. In February 2018, the state of Alaska sought certiorari on behalf of Officer Neves. At that time, the Supreme Court seemed set to resolve this very issue of probable cause and whether it precluded First Amendment retaliatory arrest claims in another case, Lozman v. City of Riviera Beach. But when the court ruled in the Lozman case in June 2018, they did not decide the broader issue. They ruled more narrowly that a retaliatory arrest claim could be pursued if there was proof of the existence and enforcement of an official policy motivated by retaliation. The very next week, the court granted certiorari in the Neves case to determine whether probable cause precludes a retaliatory arrest claim when the plaintiff does not allege he was subjected to an official policy of retaliation. Our advocates tonight are Willie J. from the Goodwin Proctor law firm, representing the petitioner, and Pam Carlin from the Stanford Supreme Court Clinic, representing the respondent. Pam, I should mention, had earlier represented Fane Lozman in the Riviera Beach case from last term. So with that bit of background, we are ready to start our preview and start our moot court.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Where's the
I'm just gonna have to sit back here. We will now hear arguments in number 17-1174, Neves versus Bartlett. Mr. J, would you like to reserve some time?
I'd like to reserve 5 minutes with the court's leave.
Thank you.
Madam Chief Justice, and may it please the court, retaliation is easy to allege and all too hard for an officer to disprove. It's all about what's going through the officer's head, often in a split second, often in a remote location in the field. And in the field, there are many permissible reasons why the content of speech creates a legitimate law enforcement reason for the officer to be thinking about that speech in addition to the other facts and circumstances that give rise to probable cause to arrest.
Mr. J, what about situations where it's not in the officer's head? For example, the Ford versus Yakima case where he says, if you had talked to me and behaved like a human being, I'd give you a ticket, but because you were rude to me, I'm taking you in. Is that hard to discern? Is that hard to figure out?
So I think I'd begin by answering, right, that in the mine run of cases, that is not what we're talking about. I'm happy to answer the question, but I think it's important to set the stage, as the court did in footnote 10 of its decision in Hartman, by emphasizing that the court is going to make a rule for 1983 actions more broadly and not for the unusual case. And
But why is that? What's the need to have sort of an over-inclusive prophylactic rule? Why can't lower courts sort of sort through and figure out which cases are easy, and then, you know, maybe you have a presumption that in the hard cases, qualified immunity?
Well, so two answers to that, Your Honor. And I'd like, with your permission, I'd like to just take qualified immunity first, because I think it's fairly easily dealt with. In circuits that follow the rule that the Ninth Circuit follows, the qualified immunity does no work in the analysis. None, because it is deemed clearly established that if you are thinking about retaliating against the arrestee on the basis of his or her speech, then you are violating the Constitution. And what's being litigated is instead the fact question. Was that what the officer was thinking or not? What was the but-for cause of the arrest? So this gets back to the first half of your question. And in all of those cases, I think the Ninth Circuit has said this itself, in all of those cases, you're not just cases in where you might have a statement by the officer, but in all of those cases where the plaintiff can plausibly allege that the officer is aware of the speech, it's going to be extremely easy to get not just past the pleadings.
Can I just, so I can understand why you might ask us to come up with a different approach, why that particular approach might be a problem, but I still don't see why we have to throw out sort of the baby with the bathwater. There are going to be some cases where it's really easy to prove, and nevertheless, you're asking us for a rule where people will not be able to go forward in those cases, and I don't understand the necessity for that.
I think the necessity of that really comes from the Mount Healthy framework that, as was argued to this court last term, is one of the supposed brakes on runaway liability for officers dealing with split-second judgments, like in this case. And the reason why I'm saying that is that Mount Healthy doesn't ask for objective evidence. Mount Healthy doesn't ask for a smoking gun from the officer. Mount Healthy doesn't ask for video before you shift the burden to the officer or the government actor to disprove that protected speech was the motivating factor. In other words, to prove affirmatively that the arrest would have happened anyway. And to do so, the officer has to credibly.
But does the plaintiff not have to plead plausible facts that it was based on speech? So it's not as though someone just comes in and says, you arrested me. I think you arrested me because of my speech. They have to plead a basis. What is a sufficient pleading to get to before you would even shift the burden that you're talking about?
In the Ninth Circuit, if you look at the joint appendix in this case,
what's your opinion of what a sufficient pleading would be?
So we, of course, are asking the court to adopt the rule that a lack of probable cause is an element of the offense.
I'm asking you what sufficient, how much do they have to do to even be able to claim the mantle of First Amendment protection? I don't want to get to the rule. I want to know what you think they have to allege. Can they just come in and say, I believe I allege that I was arrested because of my speech. I was speaking at the time, and that's enough? Or do they have to give specific facts?
I think that
they have to say what they were saying and why they believe the officer was motivated by that.
So I think that they do have to, of course, plead a plausible case. But I want to make sure I understand the question. You're asking me not to answer with respect to the probable cause element. They were asking the court to
I'm just trying to
adopt.
figure out, yes, you sort of seemed it was immediately going to shift everything over to the defense side, make them have to sort of prove the arrest would happen otherwise. And I'm trying to test what happens before we get to that stage. What has to be pled just to get into the door and have a viable enough claim of retaliatory arrest to get to that point?
Right. So the test, as we understand it, comes from this court's decision in Mount Healthy, right? And the first step of Mount Healthy is to allege that protected speech is a substantial motivating factor in the arrest decision.
What facts are alleged to that's what I'm trying to get at. They can't just come in and say anything. There really is some check right up front on alleging facts that show a substantial motivation, correct?
Right. So I think
that's not an empty test for you. That has some protection.
We would love to say that is robust protection, Your Honor, but I think if you look at the realities of the cases as they are litigated, including this case, if you look at the pleadings in this case, now, sure, I may say to Your Honor that we think that they didn't plead enough to get over proper interpretation of 12b-6, but we also don't think that announcing an interpretation of 12b-6, which of course has to apply to the mine run of cases, is the correct way to deal with situations like this. So we think that you do have to indeed allege plausible facts.
Have you discerned a real problem in the circuits that follow the same rule as the Ninth Circuit? Has there been a real problem of really insufficient pleading, really nothing all that plausible, and they're still getting to the next step in the litigation?
So in this case, it is plausible in the bare sense to say, I engaged in protected speech, and this I think is the key element that you would at least have to allege. The officer was aware of it, and I allege that that was the basis for the officer's action. That is a factual question. It's not a legal conclusion, and by pleading it, that is enough in the circuits that follow this rule to get not just to discovery, but I would urge you to look actually at the Ninth Circuit's decision in Dietrich and in the District of Oregon's decision following this rule in Mihailovici, in which they basically say all of these cases have to go not just past pleading, but past summary judgment to trial.
How many circuits in addition to the Ninth Circuit have the same rule?
I think it depends on how you count.
How many circuits don't have the rule you want?
How many circuits don't have the rule that we want? I think the answer to that is 4.
Is there a much larger uptick percentile-wise per capita, because the Ninth Circuit just has more people and you can't do it that way? Is there a larger percentage per capita of these claims in those jurisdictions?
I can't quote you with statistical significance the results of an empirical analysis, but what I can point you to is decisions actually applying the precedents of those circuits, like the ones that I just alluded to.
They're not going to get kicked out of the door up front with the probable cause test you want, but a lot of the thrust of your argument is we have to have more protection.
It is.
And I'm trying to figure out if there's a problem that we need to solve here.
So I think that is the right approach, and I think that the court should be looking at it from both ends. Is the other side's rule solving a problem that doesn't exist?
Well, I can ask them when they get up, and I'm asking you right now if you're solving a problem that doesn't
Absolutely,
exist.
and here is what we understand the empirics, like the actual cases on the ground, resulting from exhaustive research now in 2 cases on the merits in this court by both sides and a bunch of amici, that we are not aware of any case in which, at the end of the day, the officer is actually held liable.
Not my question.
Hey, counsel, I have a question. Have you ever gone on a ride-along with police?
Yes, Your Honor.
Okay, because when I was a police commissioner, I did that, and I discovered that very frequently what an officer in the field would do when he encountered somebody on the street who may or may not plausibly have been involved in wrongdoing, it seemed to me that the attitude and the comments and the verbal expression of the suspect had a tremendous influence on what the officer would tend to do. Do you think it is not a problem at all, or not a fact that police often react to the way to what they hear from people who they may be talking to?
Of course, officers react to what they hear, and where I began my argument, Your Honor, is the point that in many instances that's entirely legitimate.
Right, and what about those that aren't? Let's leave those aside. Is there any remedy? I mean, is it just the price of doing business that you say the wrong thing to a cop and sorry, there's no remedy? Or is there some legal method to discourage or deter that kind of misconduct?
There are, Your Honor, and the question in this case, of course, is whether it's one particular remedy, whether it is a tort remedy under Section 1983, not whether there is any way to root that out at all. And of course, it is not in the state's interest to have its troopers kind of pursuing their own personal vendetta.
Wouldn't risk of liability be a good incentive for the city attorney and other officials to send out a bulletin in the police manual emphasizing the importance of avoiding retaliatory arrests? Isn't that why we have isn't that the whole theory behind tort liability?
As in cases like Hartman, the court has weighed the benefits of the deterrence that a liability regime might create against the cost that it would impose. And in this case, the cost that it would impose would be that in every single case in which someone who's in a confrontation with an officer starts shouting what is admittedly protected speech, not a true threat, but, obscenities, or it could be anything from the serious and substantial.
So, counsel, let me ask you where I thought Justice Braven was going with his ride-along. that just as it's very easy for a defendant to claim retaliation, according to you, it seems to me it's also very easy for a police officer to find probable cause for whatever minor little misdemeanor, little whatever, that would erase any, under your theory, erase any chance of a retaliation claim. So let's weigh the equities there as well.
Sure. And
just if I may, just briefly to piggyback, it's not only what the officer thinks at the time. Here, right? It was some crime made up after the fact.
Not so in this case.
Or in some case that I read. Sorry, you know.
Sure. And those
in
are
Lozman, right? That was Lozman.
Those are the facts of Lozman. But of course, you know, in this case, you know, the court is dealing with the
risk remains.
Sure. And I'm happy to deal with the hypothetical, just as long as we're clear that in this case, you know, the arrest is for facts that the officer saw right in front of him, the officers saw right in front of them, and it's, I think, not disputed at this point that there was, in fact, probable cause. So probable cause is not only an objective screen, which has been something that this court has striven for in all of its 1983 cases. In Lozman, it pointed to the policy that was the decisive factor. The fact that it was objective evidence as a key reason why the court adopted the rule it adopted in Lozman. Same in Hartman. And in a lot of these, in multiple contexts under 1983, the existence of an objective screen, one that doesn't depend on a swearing contest or a jury issue about what a particular person was thinking at a particular time, that is an important virtue. And this court's suggestion that probable cause, you know, can be found fairly easily, we submit that there are limits on that. Not only are there ways for local jurisdictions to limit the offenses for which their officers have arrest authority, and this is discussed in this court's decision in Virginia versus Moore, but this court has, for many, many years, resisted getting entangled in the question of...
If we're supposed to rely on other protections, that law enforcement agencies have done any of these things. How often are people getting remedies for suppression of their retaliatory arrest for speech through other avenues? Or how often are police officers disciplined? Do you have any evidence that any of those things actually work?
But my point, Your Honor, is I would love to be able to say that. And I think the reason that I don't have an example for you is that we have found no case in which the tort system, you know, where there are incentives to pursue them, especially in
I'm talking about the jurisdictions that have the probable cause rule you want. So they just can't hardly get into court at all anyhow. And so what are those jurisdictions doing to protect, because just because there's probable cause and not a Fourth Amendment violent doesn't mean that, in fact, the officer was not engaged in retaliatory arrest. It is, as you said, an objective test. It
is an objective test. And
so it could wipe out cases where there was, in fact, a retaliatory arrest.
I think what I would point you to, and I believe this is discussed in the District of Columbia's amicus brief, is that every jurisdiction has every reason not to want their officers to go rogue and pursue their own personal vendettas. They train against it, and they discipline when it occurs.
What is their incentive? There's not going to be any damages actions. What is the incentive?
Their incentive, Your Honor, is to ensure that police officers are, in fact, enforcing the law and not pursuing their own agendas. That's not in the public interest.
Well, you just said the two can get wrapped up together.
I'm sorry, Your Honor?
You said the two can get wrapped up together all the time. That's one of your points. And you come and talk about other remedies. That was one of your answers here. And I'm trying to find out, in a case where there was actual retaliation, but there was also probable cause, what remedy is that?
I think, so the remedy is not a damages remedy or a monetary remedy for the person who's complaining. The remedy...
What remedy is there's nothing for the person that's complaining.
That's a consequence of the tort system that Congress has adopted and the way this court has interpreted the remedy. And as the court said in footnote 10...
The tort system Congress adopted? They enacted 1983.
Correct, Your Honor. That's what I'm talking about. And as this court apply in a Bivens case, but making absolutely clear that its holding applied to 1983 as well, in Hartman, in footnote 10, said that it was going to create liability rules drawn from the common law.
There was a lot of that opinion was focused on the unique problems or the unique challenges with retaliatory prosecution and proofs, in particular because they're not going against the prosecutor. That doesn't fit the situation for arrests here.
I respectfully disagree, Your Honor, because if you ask whether the situation of the and remember, of course, that the defendants in Hartman were law enforcement officers, not prosecutors, because of immunity. If you ask whether the situation here is closer to the situation in Hartman or closer to a situation like in Mount Healthy, where you have a school superintendent at the end of the year deciding whether to renew a teacher's contract for another year with the luxury of time.
Like in employment retaliation cases, it is quite common to have multiple people involved and even to have cat's paw situations where the person making the firing decision is not the one who had the discriminatory motive. You can have complicated causal chains in employment cases just like here.
You absolutely can, but what you also have in the situation like in Mount Healthy and other First Amendment retaliation cases like the patronage cases that this court has considered is time. You have the luxury of time. You have decision makers who can document what they're doing.
What if the charge was race discrimination instead of retaliatory arrest? Then probable cause doesn't let officers off the hook, even if it's a split-second decision, does it?
So that context is different in at least two very important ways. One, I would point the court back to its decision in Armstrong, and it really highlights the differences in what the plaintiff must come forward with before litigating a claim. In the circuits that have adopted Armstrong as the rule for a claim challenging a race-based racially discriminatory stop or arrest and so on, you must come forward, as in all cases under the Equal Protection Clause, with evidence of both subjective and objective discrimination.
Mm-hmm.
And that means that the plaintiff has to come forward with something. It could be comparative
evidence,
evidence,
if we did that
example.
test? Why would that test not work here? Subjective and objective evidence of retaliation.
That certainly is not what the plaintiff asked for. It is certainly not the rule applied by the Ninth Circuit. And that would certainly be better than a world in which Mount Healthy, where the plaintiff need only allege enough to think that one of the causes going through the officer's head when he made that split-second judgment was...
Can I ask you to go back to Justice Epps, where he started us with the case where the retaliatory motive is manifest, and this connects what you were talking to Justice Millett about. So let me tell you my concern, that when the motive is manifest, and these days it's likely to be on someone's video, their camera, it's going to be all over Twitter, and you actually have a case with an officer saying, F your sign, I don't like your sign, get in the car and I'll figure out why I'm charging you later. That is so corrosive to have that out in the public, and then to have to tell the public that person has no claim. We actually do live in a society where the police can arrest you because they don't like what you're saying, even if what you're saying is criticism of the police. I'm so worried about those cases that I want to know, isn't there something short of an absolute bar saying those cases, there's no claim in those cases, no matter how bad they are, because we have a filtering problem. There's no other way to deal with the issue you've identified about frivolous litigation. Isn't there something else we could do? There could be maybe a presumption that if there's probable cause, most likely that's why the person was arrested. But, if you've got direct evidence of retaliatory animus, you can still go forward. Why does it have to be all or nothing for you?
So I think two answers to that, Your Honor. So the first is, why, to get to your question of why can't it be some kind of presumption and so on. The other side, I think, has suggested that it should be something akin to a jury instruction that says, jury, consider the fact that there was probable cause. Now that, of course, does nothing to solve what we understand to be the basic problem that every one of these cases can, through allegations, get to the jury.
Mr. J, do you know what kind of cases we're really talking about? I mean, we're not talking about police who arrest someone for murder, because they talk back, right? Are we really talking about very sort of nuisance, extremely minor infractions and misdemeanors? Is that the kind of case where this will arise? Or are we talking about police like in Colombo or something, framing someone for a tremendously significant crime?
So I'd resist your characterization on the facts, Your Honor, and I would urge.
Well, I'm asking.
Sure. So I would resist your characterization on the facts, and I would suggest that the court needs to adopt a rule that doesn't try to pick through the offense of arrest, based on characterizations of it. And here's what I'm saying. So this case, of course, you might characterize it as a minor dispute. Of course, as the prosecutor's, I think, unrebutted testimony indicates, there was probable cause to prosecute Mr. Bartlett for assault. I think no one would characterize assault as a minor crime. And
Wasn't
my point,
important enough for them to carry through the prosecution.
that's
right?
correct, Your Honor. That's been explained in the record as this happens in an extremely remote area of Alaska, and they had to make kind of a resource judgment. That certainly doesn't undermine.
The judgment would be that it wasn't that important, or else they would have.
I don't think you can make it. I don't think you can characterize that as showing that the laws against assault are not important. And I think that this brings up kind of a broader point.
Sorry, the
and
assault is what, the finger in the face thing?
Yes, Your Honor.
So imagine it was my kid that this officer was questioning, and I see an officer questioning my child without me being present, and I go up, and it's a loud party, so I am talking loud, and I probably would be anyhow because I'm mad. And I got my finger in the face saying, "Don't you dare speak to my child without me present." Is that an assault?
Of course, that would depend on the elements.
I do everything that Mr. Bartlett, but Mr. Bartlett did.
It could be
my child.
So under the Alaska assault statute, on the facts as you've described, sure, it could be. And the question is, if it's a problem, Your Honor, it has to do with what is assault in Alaska, and it has nothing to do with the liability.
But the problem, back to Justice Greenhouse's hypothetical, is that what's an assault, what's disorderly conduct, what's disturbing the peace? You can find anything to arrest these people for. At the time, after the fact?
So I'd like to answer that question, and I'd like to reserve the remainder.
Can I get one question in before you sit down? It'll be a fast one.
Could I answer the question
Sure.
that was pending? As I understand the question, I think this goes back, as you said, to Justice Greenhouse's question. Isn't there always going to be something? I think that as an empirical matter, no, that's not correct. But B, ultimately, this court has not gotten into the business of second-guessing legislatures in what they decide to A, make criminal, and B, allow officers to conduct arrests as opposed to issuing tickets. That's something that, in an unbroken chain from Atwater through Virginia versus Moore, the court hasn't gotten into that business, and I would urge it not to do so here when the rule that we've proposed creates an objective screen that avoids all of those problems.
I know you want us to get to this question of whether, if there's probable cause, you win, but do you need that to win this case? Does the other side have enough to survive summary judgment, even if we don't rule for you on the probable cause question?
They don't, and this, of course, gets back to the second half of my answer to Justice Harris's question, which is, what rule could be adopted here? And I think that in this case, right, this case was judged by the Mount Healthy framework, so it was extraordinarily easy for the plaintiff to shift the burden. And and if you look at the Ninth Circuit's decision, you'll see that what they relied upon was the supposed statement that I bet you wish you'd talk to me now, because this is a case like Scott versus Harris where there is video evidence. And the other side has admitted that statement appears nowhere on the video. So no, we don't think that this is such a case. We don't think that the plaintiff could survive summary judgment. But that's why we have asked the court.
Is that a sworn statement by him? Did he do a...
It's a response to an RFA, Your Honor, of request for admission.
Why isn't that summary judgment evidence? Just because he said it? You say that wouldn't be enough evidence. Why isn't the fact that someone says, under oath, I'm going to say that this is what was said, that's not summary judgment evidence?
We think that just as in Scott, right, where the plaintiff characterized the crazy car chase, but there was video evidence refuting the plaintiff's characterization of that ought not to withstand.
This video doesn't refute it, because he said it would happen when we were getting in the car. It could have been after the video stopped showing.
Sure, I take the point, Your Honor. And of course, that is not the question on which we asked for review in this court. But I took the question to be: is the plaintiff entitled are we entitled to summary judgment kind of on other rules? I think the answer to that is yes. And ultimately, it's because whatever rule this court adopts, we urge it to be a rule that takes account of the fact that it is extraordinarily easy under Mount Healthy for a plaintiff even where there is no smoking gun, there is no video evidence, there is no admission by the police officer, merely to allege that that's what the cop was thinking. It shifts the burden to the cop, and the result is a bunch of trials trying to dissect months or years later what was going through a cop's head in a split second months before. If I may, I'd like to reserve the balance of my time.
Thanks. Ms. Carlin.
Madam Chief Justice, and may it please the court, I want to clear out 4 factual issues before I get into my argument. The first of these is that Mr. J says that probable cause is not contested here. In fact, it is contested, and if you look at the appendix at page 2, the Ninth Circuit did not find probable cause for any crime here. They found that the judgment for the petitioners should have been affirmed on the basis of qualified immunity on the Fourth Amendment claim. So there has been no finding of probable cause by the Court of Appeals. The second thing is that the arguable probable cause here, or at most the probable cause, is only for misdemeanors, and that will turn out to be critical for a reason I'll turn to in a moment. The third thing is that the district court, because it didn't apply the Ninth Circuit's rule, never analyzed any of the evidence of the First Amendment retaliation here. And so that issue should be remanded in any event to the district court for redecision. And the fourth point is about the video, which is under Alaska policy, and this is in the joint appendix, Sergeant Nieves should have had his own audio recorder on the entire time for the encounter with respondent, but he didn't have it on. So had he had that on, it might have enabled him to move for summary judgment, but his violation of Alaska trooper policy caused the problem.
Wait a minute, let me just ask, are you saying that we really shouldn't even be deciding the question that was presented to us, that we took it on with the probable cause?
The question is not presented by this case because there is not a finding by the Ninth Circuit that there was probable cause.
So what do we do? Do we dismiss, do we dig it?
Dismiss certiorari is improvidently granted. But if you want to continue, but wait, there's more. The method that this court has always used in thinking about the elements of a Section 1983 claim is to look at what the common law was in 1871. And it is critical to understand something here that no one has focused on yet, which is that in 1871, probable cause for a misdemeanor was not a defense to a false imprisonment claim. Only a felony, only in the case of a felony was probable cause a defense. So I'd like the court to look back at the cases from the 1870s through the early 1900s. And I'll just give you one example here, a case called Stern against Titus, which was a false imprisonment claim in New York. And the officers argued that they had probable cause to believe that the arrestee had committed a misdemeanor. And the New York court says, to justify an arrest without a warrant for the commission of that offense, the crime must actually be committed or attempt made to commit it in the presence of the officer. And here's the money language. Reasonable suspicion or probable cause to believe its commission is not sufficient. And there are cases like this from jurisdictions across the United States saying that when an officer
Are you proposing a misdemeanor felony line?
I'm simply saying that in a case like ours, you would affirm.
So are you proposing that we adopt a misdemeanor felony line? Because I don't have any idea of what.
No.
How is an officer going to? An officer may not know at the time whether the offense in front of her is a felony or misdemeanor if it turns on, the amount of drugs or something like that.
I think the Ninth Circuit rule is correct. I'm simply pointing out that the arguments, for example, made in dissent by Justice Thomas and Lozman last term focused entirely on cases with felonies. That is, probable cause was not a defense to an arrest in a misdemeanor case.
I thought when you were asked last term about doing a felony misdemeanor line, you thought it wouldn't work because what counts as a felony is very malleable between states, and the same thing worked for misdemeanors. This is a surprising line to propose.
No, I think the correct line is to stick with the Ninth Circuit rule. I'm simply saying that you can't find any support for applying a different rule in this case.
Do you agree that there was a common law rule where probable cause for felonies was sufficient to fend off the false arrest claim?
No, we don't agree to that either. And we'd refer the court again to the Dinsman case, which we discussed last term in our brief in Lozman, which is a case involving false arrest, a false imprisonment claim, and the court there.
But I thought malicious arrest, which I thought was a form of false arrest, does require probable, or
malicious prosecution.
No probable cause.
No, malicious prosecution.
I thought also malicious arrest.
I don't think there's a tort of malicious arrest. I think there's a tort of false arrest, which is also sometimes referred to as false imprisonment, and then there's a tort of malicious prosecution, which means that the legal process goes forward after the arrest.
But can I ask you a question just historically? So you're saying in answer to Justice Millett that you're not really principally pressing this felony misdemeanor distinction, but help me with the 19th century cases, because I guess I took the implication of your historical survey to be misdemeanor ain't enough, and therefore maybe there are some cases out there that suggest that felony is enough to sort of whitewash this.
So here's the basic idea. The basic idea is this is not a case about whether there was a First Amendment violation or not. I think we're in agreement, both petitioners and respondent, that when a police officer arrests somebody in order to retaliate for that person's First Amendment protected speech, it violates the First Amendment. The sole question in this case is whether Section 1983 gives a cause of action for that. And the question is, how would this court inject through 1983 an element that you show no probable cause for a First Amendment violation?
Well, let me ask you, counsel. I mean, your rule, does it almost invite, suspects to talk back to cops? I mean, to get an automatic, mini trial on retaliation? I mean, if there's always going to be this test that you have, or if you're going to diminish the value of probable cause, I mean, why wouldn't you? In other words, doesn't it incentivize everyone to talk back to make that claim?
Well, once you've been arrested, talking back after the arrest doesn't have anything to do with
Well, before the arrest, just as we had in this case, where the police officer, he hasn't arrested Bartlett yet, but it's not a courteous encounter all along.
But I think what you're proposing is somebody who hasn't been arrested yet, in order to potentially bring a Section 1983 claim against an officer he's angry to, will taunt the officer into arresting him and then claim, you arrested me under the First Amendment, and that just strikes me as implausible.
No, but maybe he'll... Well, go ahead.
No, I was going to say, no, but we can see that there are many instances prior to the actual arrest moment, the arrest epiphany, if you will, where it's pretty clear where things are heading or where they might well head, and as was the case here. And I just wonder, why wouldn't it, why wouldn't that be an incentive? You see, that's the way things are going to create more friction between police and the citizenry if in these kind of encounters.
Well, there's no support anywhere in the Ninth Circuit cases to suggest that people deliberately engage in First Amendment activity to provoke an arrest.
You don't hear me. I don't say to provoke an arrest. I meant you have a situation where, as you have here, a sort of a disorderly situation where arrest seems likely or quite possible. Police have shown up. That's my point. And word might get around. That's obviously what the police are afraid of, right? They're afraid of this becoming a automatic procedural element of every minor case that comes out.
Well, but this has been the rule in the Ninth Circuit for 12 years, and we don't see that. There are 27 reported cases in the Ninth Circuit that involve retaliatory arrest claims. 22 cases. Of those 22 cases, in 10 of them there was no probable cause for the arrest. So those cases would go forward under any theory. In 2 of them, there was an excessive force claim under the Fourth Amendment, and this court has already clearly held that probable cause for an arrest doesn't defeat an excessive force claim. So those cases would have gone forward. And in the 12 cases where courts let the case go forward on a discriminatory motive, 3 of them involved long-standing, repeated interactions, and I know before you were a police commissioner, you were a journalist, often with journalists who were then arrested on minor misdemeanors. And 5 of them involved direct evidence of discriminatory purpose. So let me just, you've heard
Can I ask you something on the speech that he claims he was retaliated for here was actually not just First Amendment, but on his version would have been, I think, a Fifth Amendment right to not talk to police officers, right? Is there, or imagine...
And it's also a Fourth Amendment right to not, when Fourth
Amendment, sorry, yes.
Yes. Yeah.
So, and we're talking about this as First Amendment retaliation. I take it the same rule is going to apply to retaliation for the exercise of any right under the Constitution, other than, I guess, equal protection discrimination?
I assume that's the argument that petitioners are making.
Ninth Amendment retaliation.
Well, I'm thinking Second Amendment.
I'm trying to figure out about the Ninth Amendment retaliation. Right? You reserved a right, and then they
and Ms. Carlin, I just want to double check. There is no question that is in the record, correct? Mr. J referred to the video cam, but there is part of our Ninth Circuit record before us that he did say, "Aren't you sorry you didn't talk to me before?"
It is in the Ninth Circuit record. He filed an affidavit saying the officer said that to him once they got into the car.
Counsel, I'm still stuck on whether you can get over the summary judgment hurdle, putting aside the probable cause. If you don't have that statement, do you have a claim?
Well, we do still, for a variety of reasons. There's a passel of evidence in the record, none of which is discussed either by the district court, because the district court thought once it found probable cause for an arrest, that was enough. And incidentally, they did not find probable cause here for the offense of arrest. They found probable cause, as in Lozman, for later after acquired.
So what? So just give me a flavor of what else you have, because
Sure.
You can look at this
Sure, if you
statement and it's it's ambiguous at best in terms of what the officer is talking about. And I'm concerned. I'll just tell you my concern. My concern is, well, this didn't seem like a whole lot for somebody who's arrested to have to do. Just assert that an officer said this ambiguous statement, and boom, I've got a First Amendment or Fourth Amendment claim or Ninth Amendment, whatever it is, to get into court. And I want to know kind of what we're dealing with here.
Sure. So in the record, in addition to this statement, are the following facts. The officers changed their testimony after the video came out. That is, they made claims about the arrest before anyone discovered that there was this little snippet of broadcast video that was still available. Most of the tape had been destroyed by the time we discovered it. And those claims, the officers, for example, made claims earlier in their reports that they weren't unwilling to make once they were under deposition. We had, if you look at Exhibit F to our response to the motion for summary judgment, we had an expert report by someone who had been a police chief for 29 years saying he thought, based on reviewing the officers' statements, the arrest reports, the officers' depositions, and Alaska policy, that it was more probable than not that the arrest here was, and I quote, for contempt of cop, rather than for any misdemeanor. So there was certainly enough evidence here to get to a jury, and none of that evidence, again, I'll emphasize, has been discussed by any court at this point, because the district court got the law wrong, and the Court of Appeals simply was explaining why that error in the law wasn't harmless error.
Can I ask you about something else real quickly? I would like, and I may ask your friend also. He indicated that states have all kinds of mechanisms to adjudicate and settle this kind of thing, and states are really interested in making sure that police officers behave nice, and so we don't need 1983 liability. Can you just briefly tell me what you think of that?
Well, I can respond to that in two ways, one empirical and one doctrinal. The empirical response is there's a brief in this case, as there was in Lozman, from the National Association of Cities and a bunch of other jurisdictions. They cite the fact that they have internal investigations. None of them ever points to a single example of an officer being disciplined for retaliation when there was probable cause. The United States, in its brief, talks about criminal prosecutions under 242, I believe it is. They point to not a single example in our recorded history of that. And it's not because they don't know officers are retaliating, because the Justice Department filed a report saying officers in Baltimore are retaliating against people for exercising their First Amendment rights, and yet no one has been prosecuted. That's the empirical answer. The doctrinal answer is to ask this court to look back to its opinion in Monroe against Pape, the foundational opinion on Section 1981, which says the presence of state remedies is irrelevant to whether somebody should have a claim under Section 1983 for damages. And I can't emphasize enough, this is a case about a statute. And the statutory language here says that every person is liable when they cause a deprivation
Your position that if someone who's been arrested files an affidavit or in a deposition says, the officer told me as he was shoving me in the car that this will teach you to shut your mouth and not talk like that, that those will all go to trial?
Well, it would depend on whether a district court, and the district courts have been very sensible about parsing these out, finds that allegation plausible under the circumstances.
Oh, wait, you've got someone who's, the circumstances are the same as here, right? There's no video of it, and you've got this heated exchange, but no one actually came to blows. The person's thrown down, and then as they're getting to the car, that's what they say, right? And that's all they have to do.
Well, if there are no indicia that they're not telling the truth, then that case may well have to go to trial.
So what if they were being arrested for murder? and there was probable cause of murder. Would that case have to go to trial? Or is it still plausible that the reason that this arrest would not have been conducted but for the retaliatory?
Well, I think the second part of your question answers the first part, which is that ultimately the burden that the plaintiff is going to have to show here is that the arrest would not have taken place but for the protected speech. And when you have a claim like a probable cause to believe there's a murder, it is implausible to believe that there is any officer who would not have arrested under those circumstances. So whether you say that should be on summary judgment or it should be qualified immunity, those cases should be knocked out because it's simply not plausible to claim that an officer has probable cause.
Easy to say murder, all right, but what assaulting an officer?
Well,
what about assaulting an officer?
Because it depends on what you mean by assaulting an officer.
There are codes, state laws that define what assault means.
I understand that, but common law assault, for example, is simply putting somebody in fear that there may be a battery, and a battery is any unconsented to touching. So, for example, in the question that you asked to Mr. J, you said, suppose you started shaking your hand like this, and you're really angry, so you're kind of shaking like this, and the officer thinks, she may touch me at one point. That's probable cause to believe there's a misdemeanor assault.
That's exactly the problem, right? Because it's so broadly defined, but it also would be someone who says, I'm going to kill you, officer. I'm going to kill you as soon as we get out of here, and we're going to say, that's just that assault thing. That's not tough enough.
No, that's not what I'm saying. Because in those circumstances, if the officer says he shook his finger in my face and said, I'm going to kill you, there is no reasonable officer.
I'm going to kill you if you talk to my kid again.
Yeah, there is no reasonable officer who would not arrest under those circumstances, as opposed to somebody who just says, I believe that you have no right to talk to my child. Under those circumstances.
Okay, but what you're really probably going to get is, I believe you're a expletive.
And we don't see those cases in the Ninth Circuit, which has had this rule for a dozen years.
You don't think that it happens? I'm sorry, did you?
I don't think you get lawsuits under those circumstances because remember, in addition to everything else, the plaintiff, to effectively bring a Section 1983 lawsuit, is going to have to convince some lawyer that it's worth that lawyer's time. And no jury is going to award large damages to somebody under those circumstances. So the cases that you see almost entirely in the Ninth Circuit involve things like suits against Joe Arpaio, suits by journalists who have been hassled and singled out for...
He was pardoned.
Ms. Carlin, I just want to mention that you referred to the brief from the municipalities. Don't they characterize the Ninth Circuit as an outlier? And Mr. J said that 4 circuits are already in his direction. Where does the Ninth fit in?
The Ninth Circuit is close to alone on this rule, but it's had this rule for a dozen years and there have been no problems under the rule.
What's close to alone mean? Is there another circuit?
Well, arguably the 10th Circuit is in the same position as the Ninth Circuit but what happened is after this court decided Reichel against Howards, the 10th Circuit, which had the same rule as the Ninth Circuit, has simply granted qualified immunity in every case. So technically the rule is the same, that it's not an element, but because it hasn't been clearly established, they simply grant qualified immunity.
And how do the circuits treat qualified immunity with respect to Mount Healthy, which seems like this sort of multi-factor contextual thing? How often is that law deemed to be clearly established?
So the way that qualified immunity kicks in here, and I think here Mr. J is correct that First Amendment claims have a somewhat different relationship to qualified immunity than Fourth Amendment claims do, because of course if you deliberately retaliate against somebody, it's clearly established law you can't retaliate. But where qualified immunity comes in, and this actually solves one of the problems to which Mr. J pointed, is when it's not entirely clear whether speech is protected or not. That is, is something a true threat or is it just puffery? Or it comes in where it's not entirely clear whether under these circumstances you can take this speech, even if protected, into account in making an arrest. So there are some kinds of speech that are both protected and might give rise to probable cause for an arrest. And under those circumstances, courts should grant qualified immunity because it's not clearly established based on the specifics of your case that what you were doing violated clearly established law.
When your client is screaming and yelling at the officer here, and other people start gathering around and start screaming too, like, get out of here, you don't belong here, we don't want you here, you expletive, and it's getting, a bit raucous in the room, even more raucous in an already raucous room. What happens?
Well, first, we have affidavits from other witnesses who said my client wasn't speaking.
I'm giving you a
about it.
hypothetical.
Okay, because as I understood, you're saying, what about your client is there and he's speaking about.
I was right. So we have these facts, and I'm adding more facts in, right? So
Okay.
we're screaming, and there's more yelling,
Hypothetical
right?
facts.
Yes,
Yeah.
but I think it's not uncommon to have people very upset with the police intruding into a situation, and then other people start gathering around, and more start gathering. And now a lot of people are screaming at the officer.
Well, for one thing, if all of the people who are screaming at the officer are engaging in protected screaming, then the officer has no right to arrest any of them.
Well,
and if he goes and finds some trumped up charge that they all had, left their cars.
Easy to say. That is easy to say, but these things can be like a tinderbox here, and people it's easy to start getting really hostile, and then out of that, violence will erupt. And all they're trying to do is control this person so that he can he's impeded an investigation. They're trying to find out if this poor kid here has been served alcohol and it's going to end up lying face in the snow like the other kid. All right. So they're trying to do their job here, and people are getting in their way and crowding them and screaming and yelling at them and starting to really stir the pot. The police can't take the person, arrest them, and get so they can go on with their investigation.
Petitioner's own witness, the lieutenant who is in charge of this part of the Alaska State Troopers, said that because of the thinness of troopers on the ground, it was their policy not to arrest people, but to try and diffuse the situation. If you look at the tape
I'm trying to test your legal rule because, murder's over here and littering is over here, but these things where there's, resisting arrest or, disorderly conduct or impeding an investigation, they can be make weights, and they can be really serious for a very dangerous situation for one or two officers and 100 drunk, angry people. And I'm worried about how that's going to get looked at after the fact.
The solution to that problem, if indeed it is a problem, is not to create a categorical rule that says even when officers go up to a journalist and say, we should have taken care of you long ago, and arrest him for a minor crime. The solution is not to have a blanket rule. The solution there is to grant qualified immunity to the officer who could reasonably have believed that he was entitled to take that speech into account in making an arrest because there were other people around and it looked like violence was going to erupt. Qualified immunity is good enough to handle that. You don't need a rule that says no matter what an officer does, even if, for example, to go back to Justice Harris's question, even if the officer gets on tape and says, we don't like people like you here, we're going to arrest you because I don't want any Democrats in this town, and I happen to notice you were 2 miles over the speed limit 15 minutes ago, so you're going to jail. It can't be that that's what Section 1983 permits, because the text of Section 1983 does not create those kinds of immunities for police officers. It never has, and this court shouldn't do it here.
But we create them for
prosecutors. The rule seems to be that cops should just shake it off, and we should not think that the courts will be flooded with these lawsuits because lawyers don't like to sue.
The best evidence that the courts won't be flooded with these lawsuits is we've had this rule for a dozen years and there's been no flood. There's been a tiny trickle, and many of those cases were gotten rid of very quickly. Others of those cases, there was strong
rule. What are you protecting? Nobody wins.
No, people have one and they've gotten settlements.
But also, you're saying your rule in the Ninth Circuit, won't this be very disruptive across the country to all of a sudden take your rule and do it for all the other circuits?
It's not clear why it would be more disruptive in other circuits than the Ninth Circuit. I mean, you guys know the Ninth Circuit. If it's working there, it's like New York. If you can make it in the Ninth Circuit, you can make it anywhere.
So just to clarify, so you solved Mr. J's problem by your interpretation of when qualified immunity is appropriate, and have you also solved it by your interpretation of the but-for requirement? Because the but-for requirement, it seems to me, functionally could draw the line between the misdemeanor and the felony that Justice Harris was asking you about.
Yes, I mean, there are two places that but
brings
for
in
can
a
come
kind
in.
of proportionality to the analysis, right?
Well, there are two places where but-for causation could come in. One is in the sort of orthodox Mount Healthy way, where once you show that it's a motivating factor, the officer says, well, but I had probable cause, and you say, but you still wouldn't have done it. You still wouldn't have arrested me but for my protected speech. The other is in qualified immunity, which is if it is not clear that the plaintiff will be able to show the violation because it's not clear whether any officer would have arrested, then there should be qualified immunity.
Counsel, did we correctly decide Hartman when we said that probable cause is enough to kill a retaliatory prosecution claim? And if we were right there, why is this different?
Well, we take no position on whether Hartman was correctly decided or not. So you're just asking me, does Hartman control this case? Yeah. And the best answer I can give to that is no, it doesn't, for several reasons. The two biggest reasons why it doesn't is that malicious prosecution claims, which is what was at issue in Hartman, and false arrest claims are entirely different species. And the critical thing to understand here is that in a malicious prosecution claim, ultimately, the decision maker is a prosecutor who is absolutely immune from being sued. And what the court was worried about, and I think the citations to Armstrong and to Reno against Arab American Anti-Discrimination Committee show this, is it was worried that if you allow any kind of malicious prosecution claim to go forward, ultimately people are going to want to get into the files of the prosecutor and find out, well, why did you prosecute? And what probable cause allows you to do is short circuit that inquiry and just say, we're going to assume, if there's no probable cause, that it was the malicious intent of the person who's being sued. Second, the second big difference is that the causality arguments are totally different in a case like Hartman, where you have to show that the inspector caused the prosecutor to sue somebody, versus a case like ours where there's no causal link question here. The only question is, what was in Sergeant Nieves' head?
Well, isn't a but-for test a causal link? I mean,
that is not a series of causal links. That's simply a question about what motivated this person.
That's going into his mind, which probably had a lot of stuff going on this freezing cold night in Alaska, and trying to figure out what percentage of his decision to arrest this guy was based on the fear of the officer, and what percentage might be that he, remembered the way he acted earlier. I think that's a pretty tough inquiry where you're asking us to get into.
That is not the point that this court relied on in Hartman was that the causal link, which requires you to go through several people, was problematic. The question, what's in somebody's mind, is always problematic. In some sense, we can't look in their heads. And the third thing that's different between the two situations is in Hartman, there is control over what a plaintiff has to look at, which is only the offenses that were charged. All you have to show is the offenses for which you were charged were not, they didn't have probable cause, and you can proceed. Here, by contrast, because we're talking about arrests, and this court's Devenpeck decision allows you to have ex post justifications. In this case, even the district court didn't find any probable cause for the offenses that Mr. Bartlett was on notice he needed to plead something about. It found probable cause for an after acquired offense, just as in Lozman. And the idea that somebody has to figure out whether there's any offense, whether charged or uncharged, for which there might be probable cause, and has to plead that offense.
Well, when are we going to say that? When are we going to say that the police have to identify what they were arresting you for? Because they don't have to identify code provisions or anything like that, right? They should have to say you were creating a public danger, and they take you in and they let the lawyers figure out what the counts in the complaint are.
And that's absolutely fine for the Fourth Amendment. It's irrelevant to the First Amendment. For your First Amendment claim, the question should be, were you arrested in retaliation for your protected speech? Would they have arrested you?
Talking about the after acquired charges here, and I'm trying to figure out when you're going to look at when the officer decided what they were arresting you for, because that's not their job.
This isn't about the officer. I was responding to Justice Stohr's question about whether this is like Hartman, and I'm saying that's a fundamental difference, which is in Hartman, the plaintiff, the Section 1983 plaintiff, knows what he must plead and prove from the get-go, which is he has to plead and prove that the offenses for which he was indicted, there was no probable cause.
Right, but so you don't agree that if the officer said, I'm arresting you for disorderly conduct, and then later they said, no, it wasn't that, it was impeding an investigation. That's not relevant evidence of retaliation by an officer?
If it's anything, it's relevant evidence of retaliation. It's not relevant evidence that your Section 1983 claim should be thrown out, which is the officer came up with some excuse to arrest you, which it turns out he was wrong on. The fact that some clever lawyer can find some other offense for which there might be probable cause later shouldn't defeat your claim that you were arrested in retaliation for your protected speech, and that but for that protected speech, you would not have been arrested. Thank you.
Thank you, Ms. Carlin. Mr. Jay, you've got 5 minutes.
Mr. Jay, can I ask you a question even before you get started? Because I'm interested in this qualified immunity stuff. I have neither been a police commissioner nor a journalist, but I have been a lawyer for a governmental entity, and I know how to beat my chest about qualified immunity with the best of them. And my side has been pretty doggone successful in achieving a pretty robust doctrine of qualified immunity. Why isn't, as Ms. Carlin says, qualified immunity sufficient to weed out to keep cases from going to trial, especially under this multi-factor mess that is Mount Healthy?
I think in the 4 seconds remaining, I'm going to do my best to respond to that. And it really is, if you go back to my friend's answer about why qualified immunity might do some work here, I think she agreed with me that where the question is a swearing contest about causation, no role for qualified immunity, none. And that is the rule in the Ninth Circuit. She dangled the possibility that maybe when there's a question whether this is a true threat or not a true threat, in other words, is it protected speech or unprotected speech? Okay, maybe then there'd be some role for qualified immunity. That is not what these cases are about. That is not the fault line. That is not how these cases are litigated. And if you look at the set of cases detailed at pages 37 to 39 of our blue brief, I think you will see that that is correct. Qualified immunity just isn't doing the work here. But what we do urge the court to do is to do what it said in Hartman, that you should not, that rare examples are poor guides in structuring a cause of action. And in structuring the cause of action, you should keep in mind that the defendants in these actions are going to be police officers, not school superintendents making a decision at leisure at the end of the academic year. They are making split-second decisions, and we're having to reconstruct them at trial.
Your rule only apply to split-second decisions?
Pardon?
Does your rule only apply to split-second decisions?
It doesn't, Your Honor, but we're recognizing that in adopting the rule for a cause of action, as this court does in its 1983 cases, it looks not at the rare avis, not at the rare
But what about
birds.
the officer who's just been harassing somebody? I mean, the officers patrol in the same area for a long time, and they're always shaking these people down and always patting them down, and they've had a long-running problem between the officer and this person.
So,
will they get the benefit of your rule, or should we limit it to split-second decisions?
So, of course, in this case, we think that this certainly is a case about what happens in the field, about a split-second decision. And I want to make a broader answer, because this responds to a number of my friends' answers about whether there's probable cause in this case, and that is that argument is not preserved in the brief in opposition. We petitioned this case to this court on the ground that the court should answer the question whether, if there is probable cause, there can be 1983 liability in this circumstance. And the other side said, fine, hold this case for Lozman, and did not dispute that this case presents that question. But
Mr. Jay, can I quickly ask you, just to respond to the question I asked your friend, that is, you said there are all kinds of state mechanisms that are going to take care of this, and we don't need 1983 in this area. She says not. What do you say?
I think the best thing that I can point to in my negative 17 seconds remaining is to point to this court's decision in Lozman at page 11, where this court took that very seriously and said that the reason that we're going to treat governmental policies different from the actions of individual officers is that you can't rely on those mechanisms to dislodge an official policy, whereas you can rely on them to govern the conduct of individual officers.
Are you aware of any? I mean, I know the United States brief does talk about the potential of criminal liability for officers who do this. Are you aware of any prosecutions of officers for retaliation in cases where there was probable cause of some ticky-tacky jaywalking thing?
I'm not, for this reason, and it's the reason that I've given a couple of times, that we literally are not aware of any case in which a plaintiff has succeeded in proving that an officer who had probable cause nonetheless acted in a retaliatory motive, not in the Ninth Circuit, but they all go to trial, and that is the problem.
So I'm sorry, so your sort of empirical view of the world is that the reason there has never been a criminal prosecution is because it has never happened that a police officer has made an arrest for something like jaywalking or walking the wrong way down the street or parking over the double line, and it turned out to be retaliatory. That is just, we don't have to worry about it because it doesn't happen.
Your Honor, I am based in Juneau, Alaska. As you may know, you can't even drive from there to Washington. I'm not in a position to speak for the United States, and if this court had allowed them argument,
well, what's the Alaska mechanism for accountability in this instance?
There are mechanisms, both on the state and local level.
What is it in the city of Juneau?
I have no idea because but the point that I made in response to one of Your Honor's questions earlier is that it is in no one's interest, it is not in the state of Alaska's interest to have rogue cops pursuing their own agendas. We train against it, and we have policies against it, and those policies are enforceable by termination. But that is no reason to adopt a 1983 rule that treats officers in the field as if they had the luxury of time to document their decision-making, check a bunch of boxes, put up firewalls, and insulate the screaming and yelling, protected screaming and yelling, as my friend said, but screaming and yelling in a split-second decision, in a split-second situation, from their ascertainment that there is probable cause for the law enforcement to intervene in a tough situation and bring it to a close.
Your friend says even in the Ninth Circuit, this hasn't been a problem.
So I guess I would point, Your Honors, to the words of Judge Graber from the Ninth Circuit. This is in the Dietrich decision that I alluded to before, and I would urge you to look at that. What Judge Graber said is that if we don't tinker with the rules of summary judgment, so in other words, compounding the problem, then nearly every retaliatory First Amendment claim would survive summary judgment. And if you look at how the district courts have applied that decision in Dietrich, they basically say that where you have a swearing contest, there will be a trial.
Well, what if we tinkered to this extent? I mean, would you have it seems to me that the thrust of your argument...
5 minutes.
Sorry, the thrust of your argument, which is sort of persuasive, is that in most cases, the mine run of cases, if there's probable cause, that's probably why the person got arrested. It probably isn't retaliatory animus. There's probable cause. That's what police officers do. They arrest people with probable cause. Fine. But it won't always be true. And it's going to be obvious when when the proxy force is kind of weak. It'll be very weak when there's direct evidence of retaliatory animus, when the police officer says, hey, the reason I'm arresting you is I don't like your speech. It's going to be weak when someone is getting arrested for jaywalking by a narcotics officer who doesn't make arrests for jaywalking. It's going to be weak when someone gets arrested and it takes them 5 weeks to figure out what the person did wrong, and it's all post hoc. Why do you think lower courts can't deal with that? I feel like you're not giving them enough credit. Lower courts could handle a rule that was something like a presumption that if there's probable cause, probably there's not retaliatory animus, but we're going to look at all of these other factors too and see whether there really is a proxy between probable cause and non-retaliation in this case.
You can answer that question, but briefly.
As I said to Your Honor in my principal argument, we don't resist that. It would require changing Mount Healthy if you were to do it before trial. If you were to do it after trial, it would involve, at trial, it would involve instructing the jury.
Changing Mount, why doesn't it just go to this question of can the, when the burden shifts, the police officer or the government has to show this arrest would have been made but for the retaliatory animus. It seems like it all goes to that. It's all evidence of that. Probably not, because this is a narcotics officer, and look, he made an arrest because you had an air freshener in your car.
I don't think so under Mount Healthy's step 2, nor in the real world of the jury room for this reason, that what you're asking the jury or the judge to decide this question. Yes, if the law enforcement officer has probable cause, would they have carried out the arrest anyway? That's essentially a tautology if the officer is doing his job correctly. In other words, it's in every case, it's going to drop out of the case, and you're going to be back with the question, would they have, is it the speech that motivated them, or is it something else? The fact that they have probable cause, the jury is going to say, that's admirable, but you've asked us to find a causation question, not a justification question.
Thank you, Mr. Jay. The case is submitted. As we always do, we'll take about 10, 15 minutes in our conference and come back and announce the decision.
We'll talk to the lawyers first.
Pardon me?
You didn't get a trip to Arctic?
We did.
I think you have to go there.
Get up when you
It sounds like a gas.
I'm always running over lawyers.
I have seen your two great public appearances. This one and the one in Memphis.
Oh, yeah, that was a fun event. That was really good.
But you really had your stuff together. You're gonna lose. You're gonna lose.
But I'm not gonna lose it because we didn't.
I bet Pam wishes she had had this.
Like these chairs and then these things.
Yes.
Now to go through.
Yeah, no, I think Jeff was telling me that the bigger victory is his in this case.
So where's Jeff?
He's supposed to be down, he might be on the train still. He's coming down by train.
We just had Gundy argued at Hofstra by the people from the Southern District.
Oh, okay, was he there for that?
No, he came up later in the week. Well, you were terrific.
Oh, thanks, Erwin.
Great job. You know the artist formerly?
Yeah, good to see you.
You drove on the grenade. You drove on the grenade. Suspense to see what the hardest job will be.
Yes.
Representativeness.
I mean, some of it's the same. And other different
All right.
No wonder.
Yeah, so we're going to start with the plain
Yes, I agree with that, but I do think that harassment and assault, like just given the elements, like that's a big thing. Yes, but rhetorically powerful. Which in a cop case, you're not supposed to tell us. Right, that's why I thought the fault was actually a more plausible characterization. I mean, it doesn't depend on the reaction. It's kissing the cop. Yes, well, thank you for defending that point. Yeah, well, that's completely right. We took this off.
I know you're trying to
This just means they want to hold it.
All I got to say is hard cases make bad law. This is a larger set of facts. Which both did.
There's strange things done in the midnight sun. I saw you frozen man.
Somebody sitting in the theater driving. Now on the way home from work, if I go to the theater and
I love it. You guys are both awesome. Very impressive.
I'm sure you I'm sure he was drunk.
Did I go early? At least. Track and trail.
Was it Bristol?
Bristol was in the Bristol Bay.
Which is
I can't speak to that.
I was worried it was
Like a Greyhound track.
What?
This is dredging stuff. It's from long ago, 10 years ago.
Oh, cool. Well, what's new? You're just visiting.
Well, I'll never forget this. Like that scene in Fargo.
You said you're accomplice in it.
Oh, Norm, the Prowler.
And, you know, there is some kind of
Okay, could everyone sit down? We're ready to start. Everyone sit down, please.
Sit down so we can stand up.
You don't have
Yes.
Okay, all rise.
Thank you.
We're not who we are.
But this is not right. Everybody move down.
There's one more chair.
If only the real court did this, yeah. All right, thank you. Thanks. And here's something else the real court doesn't do either. Mr. J and Ms. Carlin, those were excellent, and on behalf of William and Mary Law School, we have gifts for both of you. We were all observing back in our conference room how well argued this was, and we know it took lots of work to do it, and you took a case that we weren't sure whether we should do initially and made it so much more exciting. So thank you. Thanks. And I think this is the first time that Willie's done this, but when we vote, we don't vote, we vote for educational reasons, and since there are judges and journalists here, we don't even vote the way we think it should come out.
But don't start worrying.
Anyway.
And not because Pam was suggesting all the journalists could get arrested and not have a trial. Nothing to do with it.
Anyway, our vote was 7-2. We're going to vacate and remand, and Justice Braven has our majority opinion first.
Well, you know, the experience in the street is important in the way we look at cases like this, and the Ninth Circuit experience was significant that there's not been a tremendous burden on law enforcement. But as you know, our precedent does not allow us to ever affirm the Ninth Circuit. So, therefore, we are going to vacate the Ninth Circuit decision and remand for a clarification. We agree that the police are entitled to a good faith presumption when they make an arrest if they do have probable cause, but we do not think that the presumption is impossible to pierce. And so we are going to remand to the lower court to ask them to examine or to allow the plaintiff to attempt to rebut that presumption of good faith and show that there was a retaliatory motive, and that there would be the plaintiff would have to introduce evidence. For example, does he own a houseboat? Does he regularly attend city council meetings?
It's a floating home, Your Honor.
Thank you. But we expect that the lower courts will resolve this issue and see if this case indeed can proceed past summary judgment should that presumption be rebutted. And again, thank you, counsel, for a great job.
And two among us were in dissent, would have ruled outright for a bright line rule as Willie J. has proposed based on common law principles and Hartman versus Moore, but we were in the minority. And I have to say, Pam, nobody wanted to dig the case. Maybe the real court will. Neil, do we have time for a couple questions? Or
Absolutely.
okay.
And then we'll go straight to the next panel.
Okay. Any questions for the advocates or for anyone else? Nope.
Has anybody been to Arctic Man? It sounds like super fun, and I just...
It involves, they actually, what you do is in the race, you ski down a slope really, really fast, and when you're close to reaching terminal speed, a snowmobile comes by with a thing on the back, and you grab onto that.
Are they going in excess of the speed limit?
What happens at Freezer Burning Man stays at Freezer Burning Man.
Maybe they want to make a couple of comments.
Yeah. Do either of you want to make any further comments yourselves? Without the clock running? No? All right.
Oh, and by the way, I actually really was on the police commission, so so I did speak from experience there.
All righty. Well, thank you all. And as Neil said, we'll move quickly into the next panel. Thank you again, both Pam and Ray. It's like a nightmare.
There's nothing nice in the chairs. Just your one person down there and one person down there.
That's what they did when these people thought they were let out or something.
Okay, that's a good question.
What do you want?
What'd you say?
What's your next panel?
I'm not on it.
Everything's good.
I'm going back for my younger son's birthday.
How old is he?
7.
Oh, wow, that's a nice age. Is he in secondary?
First.
I think there's more chairs than.
Yes.
There's
There's quite a forest of chairs up here. There's a lot of chairs.
Yes.
Joan's got to have a chair.
Joan, and so she's in between us. Do you have enough space?
I have plenty of space. I just have no plugs, but that's okay. It's okay. You're like me. You're always recharging.
I'm gonna wait for Joan.
I think we should.
More space here, but
That's the strangest thing.
well, we have a first name in common.
It's good to see you.
Hello, welcome. I'm Adam Liptak. I cover the Supreme Court for the New York Times, and we have a fabulous panel tonight to talk about something like the future of the Roberts Court. We had hoped that Michael McConnell would join us, but he got tied up in mysterious circumstances. We're going to try to get to the bottom of it. I've asked Ed Whelan to investigate. With us tonight, distinguished advocates, scholars, students of the Supreme Court. To my right, Paul Smith, formerly of Jenner and Block, now of Georgetown Law School and the Campaign Legal Center. Joe Biskupik, Chief Justice, CNN, Supreme Court biographer, including of a hotly anticipated biography of Chief Justice Roberts, the perfect person to give us some sense of where the Roberts Court is heading. Erwin Chemerinsky, Dean of the University of California's Law School at Berkeley. John Elwood of Vincent and Elkins, and the indispensable Realist Watch. So it was only 2 years ago, we were here basically the same night, and the subject that night, it was before the election, many people thought Hillary Clinton would be our next president, is what will poor John Roberts do in perpetual dissent? when the Scalia vacancy would be filled by Merrick Garland or a Hillary Clinton nominee. Things are looking a little brighter for John Roberts. You know what? Before we plunge into that, just in case, we do have a pending nominee, Brett Kavanaugh, and I know that people are talking about little else, and I don't want to spend the entire session talking about it, but I thought maybe before we talk about what happens if a Trump nominee gets on the court, we should talk about the status of the nomination for just a second. And I guess I'd ask Joan, who's been covering all of this very closely, to give us some sense of where this thing seems to be heading.
Thanks, and I'm glad to be on the panel with all of you and back at Williamsburg again. Unless something's happened in the last 3 hours, which is really plausible given where everything's gone, there'll be a hearing next week, right? And there'll be 2 witnesses at this point. But what I've mainly been looking at is how things have unfolded so quickly. There are a couple of people looking at me strange. Is there not going to be the hearing? David? Okay. But anyway, he's going into this hearing with such a narrow margin of error that I would be more apt to predict that we have more uncertainty for sure than we had with Clarence Thomas. I could compare the whole thing to what happened at the last minute in 1991. Jack Danforth, Missouri Republican at the time, had lined up lots of support for Clarence Thomas, so everybody was pretty locked in. Right now, Republicans hold it only by 2 votes, as we all know, and I think that given where things are headed, there is easily a 50-50 chance that there won't be a Justice Kavanaugh. It's just very hard to predict at this point, but I actually think that if she does testify, that again, things might be much more fluid than we saw happen in 1991. The other thing in 1991, it wasn't as polarized. 11 Democrats ended up voting for Clarence Thomas. Right now, we obviously have 3 red state Democrats who are in play, but Mitch McConnell obviously is really confident that he can pull this off. I just see a lot more uncertainty. So if that happens, well, first of all, we know he won't be it's highly unlikely he won't be there for the first Monday in October. And the question is whether he gets on then a week or 2 later. And if he doesn't, then how things unfold for after the midterms.
Other panelists, thoughts on where this is heading?
Well, it does seem like there's some possibility she won't show up for the hearing because they counteroffered with a Wednesday and didn't meet any of the other demands she had. And so unless something's happened in the last hour, as far as I know, at least there was some chance. A lot of people thought that she may just say, sorry, that's not good enough. I don't know.
All of us are disqualified from answering this question because none of us has checked Twitter in the last hour or 2. But my only observation is that the record is a 1-vote margin with Justice Stanley Matthews, and we're definitely in a world where we could be back to a 1-vote margin or a 1 or 2 vote margin. So there was a time in my life when I was complaining because I lived in a boring world where it was like I was the U.S. versus the Soviet Union, and the only thing that happened differently was who was on the reviewing stand with Brezhnev, and I'm done with it being interesting. I want to go back to that boring time.
Erwin, assuming she testifies, assuming she's credible, where do you see it going?
If she testifies and if she's credible, I could easily then see Kavanaugh getting defeated, because I think that then Susan Collins, Lisa Murkowski could say it's just too much in doubt to give him a lifetime appointment.
Is there time for the president to make another appointment?
Sure, the Republicans will have the Senate at least until January. And so I think for the Democrats, blocking Kavanaugh only matters if the Democrats take the Senate in November and if somehow they could keep Trump from getting a pick confirmed before the Senate would change hands in January. If the Republicans keep the Senate, then blocking Kavanaugh doesn't matter in terms of the ideology of the court. Having Amy Coney Barrett come next doesn't do anything for the Democrats. It's only if Kavanaugh is blocked and the Democrats take the Senate, and that's, of course, very uncertain.
Even then, there's the question of what could happen in November and December, which is plenty of time.
And what do you think of the Akhil Amar, Lisa Blatt argument that, listen, of the available candidates, I wouldn't have picked this guy. I'm liberal, he's conservative, But of the available candidates, you're not going to do better.
I don't think you can do much worse either, though. I mean, this is where you get to the. It's never been in American history that qualifications have been the sole measure for who gets confirmed for the Supreme Court. George Washington picked John Rutledge to be the second Chief Justice of the United States, and he got defeated by the Senate, even though he was approved as an Associate Justice, because they didn't like his views with regard to the war between England and France. When you look at the key issues where there's going to be a difference between Kennedy and the successor, and we can talk about all of these: abortion, affirmative action, gay and lesbian rights, the exclusionary rule, punishment in criminal cases, disparate impact liability. I think that Kavanaugh is going to change the law dramatically, as would Amy Coney Barrett or any of the others who are on the Trump shortlist. So I don't think that Kavanaugh is going to be better. I think all of them, with regard to these issues, are going to make a huge difference in the law and move it far to the right.
All right, well, let's, I got a little bit ahead of myself before, but let's go back to this question of where John Roberts is on this court. The rest of this discussion will operate on the assumption that Kavanaugh or a Trump nominee gets on the court, moving John Roberts to the median position. I wouldn't call him a swing justice because I wouldn't expect him to swing very much. But Joan, you've been studying the man. What do you think a Chief Justice Roberts, who's also the median justice, what kind of Roberts court will that be? That will be a wholly separate new iteration of the Roberts court, no?
Yeah, two things. The line that was said to me right after Scalia's death was the idea that life tenure for him would now be a life sentence, which is so different than where he is. But I think it puts much more of a burden on him. You know, here's a man whose instincts were much more where Sam Alito is, frankly. If he were an associate justice, I think he would line up very much with where Sam Alito is. As chief, he's moderated that a little bit for institutional reasons. Not in things like race or religion, but certainly in healthcare and in the margins in other areas. I think given what he's witnessed now with this confirmation process and how it will be a much tougher court in the public view to counter his argument that, of course, we're not politicians in robes. We don't vote based on being a Republican or a Democrat. It will be much harder for him to fight that image, which he's so invested in fighting, that I think that he will end up, again, not on issues like race or religion, but on other things, moving a little bit more to the center. He's definitely, his vote will not be in play the way Justice Kennedy's vote was in play. It won't be, he doesn't have that kind of flexible approach to the law as Justice Kennedy had. So I think naturally he would have, no matter what, he's going to pull, the court will be pulled to the right, no matter what happens. But I think that he'll have this competing issue of the institutional look of the court, and he's someone who already had talked about the taint that the confirmation process can bring to the full court. As we all know, he, 2 weeks before Scalia died, he was saying that, and then, kind of all blew up. And I think that that's only been reinforced by the process we have. Before this happened to Brett Kavanaugh, this whole ordeal, I would have thought that he might have been slightly more in play to be a touch more Kennedy-like than I think his original instincts were. But if he does get on, I just wonder what happens to an individual after what we've had. I mean, because Justice Thomas certainly has continued to talk about the sort of scarring effect of all that. And I just wonder if that would make someone like a Brett Kavanaugh dig in so much further to the right. I don't know. I mean, this is all pop psychology rather than jurisprudence, but these are 9 individuals. They're very real. They already have a reaction formation kind of thing. And I think the chief himself will definitely be influenced by the gravitational pull to the right.
Can I disagree a little bit? Yeah. I think that John Roberts, as chief, will want the court in many areas to move incrementally, and he'll be more moderate as chief than he would be as an associate justice. But I think there are certain areas where he very much believes in the traditional conservative judicial ideology, and that will take precedence to him over moving the court in a more moderate direction. My evidence that is his dissent in Oberfeld versus Hodges. I thought that Chief Justice Roberts was going to be in the majority in that case. He wants to be on the right side of history, and there's no doubt where history is going on that issue. Not only is my prediction wrong, but he wrote an angry, vehement dissent, which I think is still the only dissent that he's read from the bench.
It is.
And when I look at that, when I look at, say, his opinion in parents involved in the community schools, jail schools number 1, I think in certain issues, in gay and lesbian rights, abortion, affirmative action, I don't think he's going to be a moderate. I think he's going to push the court in a conservative direction, even though in other areas it's going to be incremental. And as the latter thing you said, having read so many of Brett Kavanaugh's opinions on the D.C. Circuit, having read his law review articles, I didn't end up with hope that he was going to be moderate. I saw him much more in a conservative mold of a Samuel Alito or Neil Gorsuch than somebody who was going to be more like a Kennedy.
So I can't believe we've gotten this far into the first set of answers and nobody has yet trotted out the old Justice White line about with every new appointment, it's a whole new court. But let me invoke that now. And if anybody knows where I can find that, I would appreciate it because I've never found it.
Oh, it's very hard to find the full quote.
Yeah, yeah. But in any event.
No, there was a USA Today article by Joan Biskupic which had it parafrased. I was looking for it just the other day.
I'm just dying to see an original source of primary
You should trot out all the banalities and trite thoughts.
Well, that's what I'm here for. I assume that was why I was invited. But, it combines the assigning power with being the median justice. And it's a point of real power. But the reason I brought out Justice White's quote is that I do think he's sensitive about appearing to be 5-4 in too many cases. So there's openings for other people like Justice Kagan to look for different ways to kind of cut a deals on cases. And again, it's not going to be the marquee stuff, but she may see opportunities to decide cases in ways that are more favorable to her views. And she could propose them to him, and he has he's in the catbird seat if he is both has the assigning power and he's the median justice.
Paul?
I think the chief may be glad he doesn't have his life sentence, but I think he's also quite aware, would be aware at this point in the history of the really severe challenge to the perceived legitimacy of the court that they're facing if they get Judge Kavanaugh on, and it's the 5 Republican appointees dominating the 4 Democratic appointees with no Justice Kennedy. The court's always has had this 5-4 wing for a long time, but I think Justice Kennedy played an enormously important role in making the public still think of the court as a court, a place where rights could be vindicated even against the grain of the Republican orthodoxy, his willingness to stand up for abortion rights and for gay rights and affirmative action, a lot of these things, even though it was a relatively small percentage of the issues on which he went to the more progressive side of the aisle, was enormously important, I think, to the way the public perceived the court. And the court now is just going to be viewed by an awful lot of people as an institution where power was grabbed, where a seat was stolen, or in the context of all of the lower courts where the judges were stalled for 2 years and now they're being rushed through. A court where the perception is that voting is along the lines of what helps either of the 2 political parties. And so if I'm the Chief Justice in that kind of situation, and I don't think I'm exaggerating it, I'm going to be looking for ways to cast a 5th vote with the other side and at least occasionally do what he did in the ACA case. And I don't think I don't think it will be in just little cases. I think he'll look for significant cases in which to offend his conservative friends as he did once in the ACA case. Which case that will be, or which cases that will be, I don't know. But I don't, and I certainly agree with Irwin, and I think Joan said this too. On race, on certain issues, he's just immovable. Roe v. Wade, I think there's no chance he's going to do anything good in that either. But I think there will be situations, and maybe in the more political cases, maybe I'm just holding out hope for gerrymandering one more try, but where I think he's going to need to do that, or the court's just going to be in a worse position than it's ever been in terms of people thinking of it as a court of law rather than politics.
But how much does he have to do it? I mean, if he does it once a term, does he send a kind of message? I mean, the way Gorsuch joined the liberals in DiMaia, and everyone goes, "Oh, Gorsuch has an open mind." Maybe it doesn't take a ton of cases for him to convey that point and still achieve almost everything that a Reagan-era movement conservative might want to achieve.
Well, I think given some of the unpopularity of some of the other things they're going to be doing in areas like getting rid of affirmative action, getting rid of abortion rights and all like that, I think it's going to take more than one symbolic small case a year send the signal that the court is still open to both sides of arguments in really important issues.
In whose eyes? I mean, last year he wrote the opinion in Carpenter, a very important Fourth Amendment case joined by 4 liberals. He wrote a dissent in South Dakota versus Wayfair joined by 3 liberals. But that didn't attract public attention in terms of the John Roberts vote. I think if you're talking about the general public's eye, they're focusing on a very limited number of high-profile issues. Right. And those are the very issues where I think Roberts is least likely to deviate from the conservatives. Maybe there'll be another Affordable Care Act, but for the high-profile issues that we foresee now, I don't see Roberts going with the liberals.
I agree that there are certain issues on which he's just not available, but I think he's going to be looking for the next ACA case, something like that, where they were about to take down the signature achievement of the President Obama, and he saved the court from itself. That's how I perceive that case.
Yeah, one thing I was going to add, I think more people, and I know this from talking to so many folks as I've been writing this book on him, are more aware of the moderation on the ACA case than his Shelby County opinion, or the dissent in Obergefell, which Erwin is exactly right. I mean, it was a very strong dissent, very surprising, but people forget about that, and because people who were in favor of same-sex marriage got what they wanted, it seemed a little less prominent in their mind. And what he might do, Adam, to answer your question about how he might navigate, again, I think race, no play in the joints. But what if he waits on abortion? Everybody thinks something's going to happen immediately on abortion, but maybe he can stall it somehow. Obviously, they only need 4 votes to take it, but he works somehow with whoever the new justice is to hold off a bit, and that becomes a little bit more of a signal that he's not moving so quickly. So, I don't underestimate his ability to be kind of shrewd in terms of the public message. And what he's playing to is not so much this audience, but people out there who continually talk about, but the chief did this in the ACA. Doesn't that mean he's not
right?
Alito?
How are they going to stall on abortion? They've got these cases coming where the laws are going to be upheld.
I mean, it could be a record thing, though, because, he's a big fan of getting rid of cases because of something in the record. And they look pretty hard sometimes for reasons why the record isn't quite right in this case. So I wouldn't be surprised with that. I mean, if you remember, what was the Austin Municipal District, the water district. It had like an O. Henry ending. It was kind of, I did not see that one coming. And I wouldn't be surprised if there's future O. Henry stories there, surprise endings.
Erwin, where do you see Roe going? I guess I walk around and say they don't want to take that dramatic step. It's bad for the court, maybe bad for the Republican Party to have a headline that says Roe v. Wade overruled. They can hollow out the decision so effectively. On the other hand, I do think, and as people have said to me after I've given those views, that there's a lot of pressure on the chief. If 4 justices vote to grant cert and the issue is squarely presented, is he going to go with the other side on that?
Since 2010, 33 states have adopted over 400 new laws imposing restrictions on abortion. The Supreme Court can uphold those laws and basically gut the right to abortion. Had they upheld the Texas law 2 years ago in Homeless Health versus Hellerstedt, it would have closed most facilities in the state where abortions were performed. So they can effectively overrule Roe without doing so explicitly. But I'm not saying that they won't do so explicitly, even if, as Jones says, they don't do it immediately, even if they wait several years. Does anyone in this room have doubt that Clarence Thomas, that Samuel Alito, that Neil Gorsuch would vote to overrule Roe? And then my instinct from having read Brett Kavanaugh's dissent, what he said at the confirmation hearings, is that he'd likely be a vote. I mean, all he said was it's precedent and double precedent, not that he wouldn't overrule it. And then the question is, if there's 4 votes to overrule it, given what we every reason to believe John Roberts thinks about abortion from his own votes on the court with regard to it, or I'll put it this way, can anyone point to anything in John Roberts' record with regard to abortion that would lead you to believe he wouldn't be a vote to overrule Roe versus Wade?
But in this idea of the alternative of just sort of hollowing it out, aren't they going to have their hand forced by things like fetal heartbeat laws and stuff like that? Which I assume if they don't have a case almost there now, they'll start passing more and more of those laws which simply can't be upheld with anything like a semblance of the Casey rule still in place.
Well, it really depends on the circuits. I mean, if the circuit strikes down a fetal heartbeat law, cert denied is pretty easy. Mm-hmm. But if a circuit were to uphold it, then the court may not have a choice but to take it.
Or a state Supreme Court or something. Yeah.
The court has so far, after announcing a constitutional Second Amendment individual right, stayed out of those cases entirely. And that's a little bit analogous to what they sometimes do in the abortion cases if the lower court strikes down the law that cert denied. But does a new court, a court with Kavanaugh on it, start to take a different approach to Second Amendment rights?
Well, I would just say there's one area that's sort of bingo for an area that doesn't mean that much to the chief. I mean, I think affirmative action for sure with all these other ones we've talked about, but I don't know that he would be a fifth vote to go as far as the Second Amendment types want. And that might be kind of a marquee area in the other direction.
But it's conceivable, isn't it, again, that if you're only looking for 4 votes, and since none of these Second Amendment cases, which come up several times a year, ever make it, that both Kennedy and the chief were voting against cert, and that maybe a Kavanaugh vote would force it onto the agenda?
Just hard to know because you don't see the votes, right?
It's hard to know.
Yeah.
And would they take it without knowing they had the fifth? Is what
Right.
sort of what my suggestion was. Unless you
But whether
take it.
Kennedy was there or not, at some point soon, they've got to start taking some of the Second Amendment cases because there's splits among the circuits as to major issues. There's splits among the circuits as to the level of scrutiny to use under the Second Amendment. There's splits among the circuits in terms of some specific regulations. And so when they take it, can we really imagine, again, one of the 5 conservative justices voting to uphold, to strike down some of these laws, to uphold some of these laws?
We've talked about affirmative action a little bit. It sounds like there's a general consensus that that is a John Roberts project, and that, let's say, the Harvard case reaches the court, as I imagine it will in the next year or two. What kind of outcome do you see there, John?
I think that there has never been anything he has written about this topic or voted on about this topic that would lead me to believe that he would do anything other than vote for Edward Bloom and his project here and the challengers to say that Harvard can't do what it's doing under, what is it, Title VI, or because it's the funding question now. It's not the, obviously because it's a private school. And we saw where he wanted to go. He laid it out so clearly in his opinion and parents involved. And at every stage, this has been one where he's been ready to pull the trigger for a long time.
The one thing, though, is just to keep in mind that Justice Kennedy was very conservative on this as well. I mean, the one exception, I mean, parents involved, even he found the actions there to be unconstitutional as well. He just didn't do it on as sweeping a ground as the chief did. And I have always thought of Fisher as sort of sui generis. Which was sort of like, hell with this, we've done, we've dealt with this case long enough. We got to get rid of this somehow. So this is okay. Mm-hmm. And so I don't know that it's going to appreciably move the needle, except for kind of in idiosyncratic ways if he is replaced by a Trump nominee.
I disagree. I think Robert's opinion and parents involved, or his opinion in Chuetti, make clear that he would want to find all affirmative action to be unconstitutional. And when applied to private universities, do the same thing through Title VI. Kennedy had, I think, a real evolution on the court with regard to affirmative action that I think we have to focus on. When he first participated in an affirmative action case in Metro Broadcasting versus FCC in 1990, he writes a dissent that likens affirmative action to apartheid. And then he slowly becomes more moderate. And in Fisher, his opinion concludes by saying there should be deference to colleges and universities in terms of how to best achieve diversity. I don't think it was just, I want to get rid of this case because it's been here too many times.
Well, no, but I think it is sui generis. And I remember his deference being, for like the goals of the educational experience and so forth, it still at least made noises about the need to enforce strict scrutiny. And I'm not sure that, what we have from Brett Kavanaugh is relatively thin gruel too. We have, a comment about in 1999, he said that he thought that the U.S. was going to erase blind constitution, which is, as an empirical matter, I think that's maybe an accurate statement because that was the Hopwood decision out of the Fifth Circuit at the time. And, if you were just a betting person based on what the way the Supreme Court was going at that point, you might have said that's correct. And when you have, what he has done personally. It may be that he is sympathetic to what employers may want to do to, have a more diverse workplace. And so, I mean, he is, relatively exemplary as far as, highbrow judges go in his hiring practices.
Mm-hmm. Justice Ginsburg not long ago predicted that 2 cases from this last term, sequels to them, would reach the Supreme Court shortly. She thought both a partisan gerrymandering case and a sequel to the Masterpiece Cake Shop case might get back to the court, and that will give us a very interesting controlled experiment about the difference between the last court and the current court. Paul, you know a little bit about the
gerrymandering's already there. The notice of appeal was filed by the state of North Carolina. They're going to file a jurisdictional statement by the end of the month. It's a done deal. There's going to be a congressional gerrymandering case this year because I don't think they can summarily affirm or reverse.
And what do you see happening?
That's why I made that speech about how Roberts is going to be looking for one case in which to vote the other way.
That's the case?
That's the case, right? That's the hope, I suppose, right? I don't
let me ask you sort of an in the weeds question.
Uh-oh.
So when Gill goes back, Kagan writes this elaborate concurrence about here's how you have to set the case up, and you come back to us, and here's how you do the standing. It did suggest she didn't know Kennedy was leaving, didn't it?
Well, she didn't know Kennedy was leaving, I don't think, until the last day. The story is, I mean, he told them after they were adjourned on the last day. But she was trying to get his vote. In any event, the North Carolina case has all of her standing theories, all of the chief's standing theories, they're all in there. So they're not going to be able to duck it on standing. The question will be whether they what they end up saying about the justiciability issue.
Right. So the good news for
some other way to duck it.
The good news for Joan and me, if not for the nation, is that we at least have one big case this year.
Yeah, and I'll tell you what I think about that case, and I'm sorry to say this, but I think the chief, remember what the chief said in response to Elena Kagan's concurrence, that could have easily been a dissent, was don't pay attention at all to her.
Right, but we don't need her standing theories. They comply with his too. I mean, it's all there. But
I don't think he wants to see your case again. I mean, he's going to see it, but I don't think he will ever. He will turn his back on you again for it. And I thought it was. I thought 2 things were revealing out of it, and we've actually seen kind of part 2 because didn't North Carolina just pay attention to what who just interpreted Kagan's concurrence in a positive way? Who just took it and ran with it? We just saw that.
It was a North Carolina.
Yeah, that's
opinion.
right.
Yeah.
So, but he says, as some of you might remember, he writes for the majority. He writes the opinion, and she writes this concurrence that lays out a roadmap for coming back to the court. And he says, remember what you should be paying attention to. Don't even look at her concurrence. Look at what I have. But as I said, I think she wrote it as a concurrence so that she could have it as a concurrence for lower courts to follow rather than a dissent, which it had a lot of shades of. But I don't think that's, if the chief is going to pick off an area to show more moderation, I actually don't think it's going to be in partisan gerrymandering.
So, Paul, your best hope is that the chief is going to embrace sociological gobbledygook.
Exactly.
And open the floodgates to all
He
these
did seem very open to it in the argument.
What about a claim of religious liberty, as in Masterpiece Cake Shop, against a law barring sexual orientation discrimination? What does a court with Kavanaugh on it do with that question the court also ducked last term in Masterpiece? Anyone?
One of the mysteries last term is why did the court grant, vacate, and remand on Orleans Flowers versus Washington State? Because the cert petition was there opposing the exact same issue. The Washington State Supreme Court had said that it violated Washington law for this florist to refuse to make floral arrangements for same-sex weddings. They decide Masterpiece Cake by saying there's religious animus in the Colorado Civil Rights Commission. Well, there's no evidence of religious animus in the Orleans Flowers case, so you'd think they would take it, but they GVR it, and there's now all these other cases pending coming up. There's a decision in June by an Arizona Court of Appeals involving a stationery store that refused to engrave wedding invitations for a same-sex couple. Same issue is going to be coming back before the court, and the question is, is there a reason to believe that Kavanaugh might be more willing to join with Ginsburg, Brierson, and Kagan than, say, Kennedy was in the context of Masterpiece Cake Shop?
Well, there's a realist backstory here, isn't there? My Masterpiece was relisted like 5 million times.
More or less, yeah. I think it was 4,990,000. Yeah, but continuing nines.
Suggesting that there was a lot of debate about whether to take that in the first place. So it may be that people don't particularly want to decide the question.
I think it was particularly hard with Justice Kennedy up there because, he loves his children equally, and he's both a big religious liberty guy, and he's also very pro, equal rights for gays. So I think it was especially hard for him. I think it becomes a much easier question for, the way I've described the separate opinions in the Masterpiece Cake Shop cases, it's like the Spanish Civil War. You have, the two different sides and both saying these are the arguments. And I think that that's probably not a hard decision for Kavanaugh. Kavanaugh is much more kind of the religious liberty side, I would think, between those two. But we'll see. I think that they probably do want to duck it for a while. They don't especially like taking some of these hot button things.
It creates such a terrible slippery slope problem if they rule that people have a First Amendment right to deny service to gay people based on these kinds of arguments. Stopping it with that is going to be very difficult unless you adopt the government's, the United States position that somehow discrimination against gay people isn't a serious problem, but black people, that's a different thing. That's literally what the Justice Department argued in the case. But aside from that argument, which I don't think the court would ever embrace, they just end up trying to figure out how do we stop the problem we create if we recognize one of these in one of these cases that people actually have a constitutional right to discriminate.
If Chief Justice Roberts wanted to show the independence of the court, you could imagine it could come up in a case, say, arising from a subpoena to President Trump from Bob Mueller, and it would test the chief in a way that United States against Nixon and Clinton against Jones did. What do we see, Erwin, what do you think happens if that kind of case gets to the court?
This is the example of what you're talking about, where I could imagine Roberts ruling against Trump and showing that the court is not just a political rubber stamp. A lot's going to depend on the way the issue gets presented, but assuming the court can follow U.S. v. Nixon, this is the place for the judiciary to stand up for separation of powers. And I can imagine Roberts taking the lead and writing the opinion there.
Totally agree with that. I think that's a case where he'll feel good about doing that if it comes up in the right way.
Yeah.
And is there any hope that, as with those other two cases, it would be unanimous?
Nixon was unanimous, and we've got to remember that 3 of the 8 justices who participated were Nixon appointees, and I think it was a really important thing that it was unanimous. And so I could imagine here too, again, depending on how the issue is presented, it being unanimous because the court is going to be standing up for separation of powers and checks and balances.
I could see also, the chief is a strong enough persuader that if he thinks it's important, I could see him trying to do it in such a way that that's easier to do. Like if they, make it very strong stare decisis thing, or they say they haven't argued hard enough to overrule Nixon or something like that, to do it that way. Because also, the Clinton versus Jones was also unanimous, wasn't it? Mm-hmm. So they really do kind of go out of their way when you consider, they had a couple Clinton appointees on there, and everybody held their nose. And I think it was written by Stevens as well, that they do kind of go out of their way in those when those things come up to try to appear unanimous.
And did Breyer
Breyer concurred in a concurrence that had a lot of dissenting feelings in it.
Right, and so that would be almost, if somebody had to split off, that would be...
There'd be a very dissenty concurrence, something like that.
I want to turn to your questions in just a second, but what discussion of the Supreme Court would be complete without administrative law? And, when you talk to the FedSoc types, they go, well, maybe I'm kind of interested in, but the administrative state is a menace to America, and something needs to be done about it. And Kavanaugh is fully on board for that theory. How does the conservative hostility to the administrative state start manifesting itself if we have a new court with a Justice Kavanaugh on it?
Well, for starters, he's written an article, and he's brought this out on kind of roadshow about how you decide what is ambiguous, and it kind of turns up the dial a little bit. There's a lot of cases where judges just go like, it seems ambiguous to me. Somebody made an argument on the other side, and he sort of dials up what it takes, and that you have to apply various interpretive devices, and if at the end of it you really are just totally stumped. Maybe it's ambiguous. And I think that maybe the first thing we see is sort of a very strong Chevron step one. He also, there's been kind of notes of this major rules doctrine in the Supreme Court in the second ACCA case. And I could see that getting some traction, which is something that Judge Kavanaugh has been strong on. And this is another area where I have to remind people that, again, the person who they're replacing was not super friendly, although I wouldn't have counted him as a huge detractor. There have been several kind of important points in his life where Justice Kennedy sort of, tapped the brakes on Chevron, including in his last term in his Pereira separate opinion.
Is a coming attraction for tomorrow, a case that will be talked about, this case Gundy versus United States, that involves with the Sex Offender Registration Notification Act is an unconstitutional delegation of power to the Attorney General. The Supreme Court last struck down a delegation as unconstitutional in 1936. If the Supreme Court were to find this to be an unconstitutional delegation, it then would be opening the door to challenges to so much of the administrative state, because almost in every area there's some broad congressional delegation to an agency.
I think that's certainly part of the program, though. I mean, if you were at a Federalist Society meeting where they're not too open to the public, they would be talking about that delegation doctrine. That is a big part of what they're trying to accomplish.
All right, your question. Did you have a point?
No, I've been dying to get this out. Just because I'm hoping that I will get royalties out of it somehow. But I view Gundy as potentially, I mean, it could be a big deal, but I mean, it's a relatively, it is the barest statement of reasons. I can see Jeff Wall shaking his head here. He's enforcing the party line, but I think most other people would say that it's a pretty bare. It's not given a whole lot of instruction from Congress to the administrative apparatus about how they should decide this. And I view Gundy as, it could be a big deal, but I also could view it as part three in the sort of, we got Lopez to say, Commerce Clause means something. We got NFIB versus Sebelius to say, Spending Clause means something. And then we got Gundy to say, delegation means something. But they managed to, if it comes out that way, they managed to pick out things which were, unicorns, where they could say, constitutional rights mean something. And, it launches 1,000 notes, but it doesn't necessarily change the law a lot. But anyway, send me money if I'm right, and if not, please forget about it.
All right, who has questions for this terrific panel? Bob Barnes.
I was just going to bring you up to date that Grassley has set a vote for Monday on Kavanaugh unless Dr. Ford and her group get back to him at 10 p.m. tonight.
Oh my God.
They will definitely show up to...
All right, so we're going to remain in session until 10 o'clock.
Whoa.
But beyond that, I did have a question, actually, which is I keep seeing commentators this week saying what a terrible month this has been for the Supreme Court with the fight over this nomination, with the issues that have come up. And I was wondering if the panel thinks that it's been a terrible month for the Supreme Court's image, and if so, why?
This is ordinarily where we reach for a water bottle, isn't it?
Yeah, I was going to say, it's been great for business, Bob.
Anytime you have a confirmation fight of this level of ugliness where it breaks down just to partisan voting within the Senate, basically you're going to get no Democrats voting for this guy, it looks like. That's got to be bad for the perception of the court, for some of the reasons I was saying before.
I'm just the moderator, but if the court doesn't want to be perceived as political, if the entire nation is focused on a political fight over the future of the court, it makes it harder for the court to maintain that aspect of its legitimacy.
I hate it when you agree with me.
It doesn't happen often. Yes.
Yes, more on Kavanaugh. We have Kavanaugh on tape talking about his drinking back in high school, and his friend, I forget his name, who has more than confirmed that. And everyone knows that people who get drunk don't always remember their actions, good or bad. I and a lot of people believe that Kavanaugh is lying with his outright denial. I mean, who knows if he did it or not? It's horrible for the woman, but he might not know that he did what she says he did. So notwithstanding the length of time, notwithstanding anything else, if there are a lot of people like me that think he's lying about it with his outright denial, wouldn't it be disqualifying for a lot of the senators just based on the lies? Since, you know, everyone knows when you get drunk, you don't always remember what you're doing.
Who would like to handle that?
What his lie is outright denial. I didn't do it. It would more likely, it should have been, I certainly don't remember all my actions. I mean, I think any truthful person would say, I don't remember everything I did back when I was drinking.
There's an 11-10 split on the Senate Judiciary Committee. If Grassley goes through with what Bob was just describing and tries to take the vote on Monday, will 1, 2 Republicans say we shouldn't go forward in such haste? If somehow they pass it 11-10 through the Judiciary Committee, will a couple of the Republican senators say this is just being handled inappropriately, taking your position that we haven't followed proper procedure? And if the Republicans were somehow to get this through in a 51-49 vote, one thing we haven't talked about is what's going to be the effect on the November election then? I mean, remember what the effect was in the November 1992 election, what happened with regard to Clarence Thomas. None of those are profound observations, but I don't know that we can do anything at this stage but think in those terms of how might it play out.
I also think that if they get a vote on Monday, Dr. Ford's going to be on television by the end of the week and on 60 Minutes or something, and that's going to be, she's going to be able to give her testimony somewhere, even if it's too late to affect the outcome of the vote. That's
the committee vote.
Committee vote, right. Because, Bob, they're not saying floor vote, they're saying committee, right?
Well, that's right.
Yeah.
Yes.
You all were talking about Roberts perhaps trying to slide a little bit to the left to keep up the image of the court. Might there, and what we talk about a political court, you've got another major election in 2020, which may impel some reasons not to move too quickly on some of the undoing that you're talking about. Do you share that, or you think that's wishful thinking?
Some of the undoing is constitutional, and that elections can't change some of those constitutional results.
But rather than go full bore for Roe or to change the Second Amendment, put it on a slow burn and wait until you see how the political process plays out in a couple of years. Or is this a real rush to judgment?
Certainly on some issues, I think they're going to go ahead and just go ahead and do it as soon as they can, politics aside. But maybe there'll be few in which somebody on the court would think in those terms. I don't know. It's hard to tell.
Since I'm saying, I feel like obvious things, Clarence Thomas is 70 years old, Samuel Alito is 68, John Roberts is 63, Gorsuch turned 51. Let's assume Kavanaugh's confirmed, he's 53. They know they're going to be together for a while, absent unforeseen circumstances. So they don't need to rush, but they also have the cases that come before them, and I agree with Paul, is to some things, they're going to be thrilled to have the opportunity that conservatives have wanted to have for decades.
Plus, I have to say, this term we already have 3 cases teed up to overrule things, and I think the chief is going to be mindful of stats. I think they're going to try to keep off further overruling till next term.
Oh, I hope so, since I'm arguing one of those cases against overruling.
Yes, back there.
So, let's say the Democrats take the Senate. What do you foresee happening with the nominations?
Will a Democratic Senate confirm any Trump nominee not named Merrick Garland?
No.
No.
Okay. On that note,
the question is whether there's.
But the question is, will there be a Democratic Senate? I think that's
well,
the real
whether
question.
there'll still be a vacancy by then anyway, right?
on that.
Yeah, but that also gives it for anybody older, an older person. It's okay then.
Okay, we're gonna have one more question. Did I see a hand?
Yeah, so if you go back 20 or 30 years, the court took 150 cases a year, and now they take half of that. We have a strong 5-justice conservative majority. Do any of you see a world in which the 70 grants a year goes up substantially from where we are? Maybe not back to 140, but substantially more than where we are. We're going to be in that level forever at this point.
Well, if you look at what the cases were in the 150 a year when I clerked in those days, a lot of it was little statutory stuff that Justice White made them grant because he would write a dissent if they didn't take every circuit split. I don't think that the conservative majority needs 150 cases a year to accomplish what it wants to accomplish, and I don't see it in the court ever going back in that direction anytime soon.
Now, there's a very interesting article by David Strauss, I think, about that. I mean, if you just talked about all the people who replaced, like every replacement was more parsimonious with grants than the people who they replaced. And I don't see that changing.
Okay, on that note, I invoke the 21st Amendment. Let's all go get a drink.
It was a pleasure.
Pleasure?
Had you guys not met before?
No, I don't know that we've...
I think we met briefly here.
I think I was distracted because I was the...
You were arguing.
I was the person last year.
Yeah.
But it's not unusual.
Which, let me tell you, it's great not doing that.
I've done it several times here.
Really?
Yeah.
You're a glutton
Do you
for
know the story of
punishment, though.
Pam? Pam jumped in at the very last minute. It was supposed to be Nicole.
Right.
Oh, really?
Yeah, and she had another commitment, and because Pam had argued Lozman that she's helping with respondents
felt like she
free.
could? Wow.
Well, she got her arm was twisted, but I'm so happy that she did it because she's so emo.
What happened